Okay, we're on the record in the matter of the people of the state of Michigan versus John Leonard. File number 23-01093. Council appearance.
Brian Ring on behalf of the people.
Matt Nagel on behalf of Mr. Leonard, both of us appearing over Zoom, Your Honor.
Thank you. Today was the date and the time that was set for a probable cause conference. Preliminary examination is scheduled for April 21st at 9:30 in the morning. Are we proceeding?
We're going to need to adjourn the preliminary exam, Your Honor. We're still waiting on a great deal of discovery.
You never received any discovery, or you were waiting for additional discovery?
We're waiting on additional stuff, Your Honor.
Have you advised your client of his rights as it relates to the timeline?
I have, Your Honor.
Okay, Mr. Leonard, you understand that you have a right to have a preliminary examination within 21 days of your arraignment?
Yes, Your Honor.
Okay, so you were arraigned back on April 5th, but due to the outstanding discovery requests, are you willing to waive the 21-day timeline so that we can reset your exam?
Yes, Your Honor.
And nobody's forcing you to do that, is that correct?
No, ma'am.
June 1st at 9:30.
I'm already engaged in several hearings out of the county at that time, on that date and time, Your Honor. Can we?
June 16th at 8:30.
16th at 8:30?
Give me just a moment.
Oh, okay.
I think I'm I'll have to make that an extra long weekend. Yeah, Monday, so I'm not gonna be here. So yeah, I'm gonna take care of that. But yeah, I think we've already filled up the first 2 months of resets anyways. Is that a PCC date? Yeah, so they're gonna go and add slot, put with the ones on there, so we're overpacking the first anyways. Just
June 23rd at 8:30.
June 23rd at 8:30.
That works, Your Honor.
First, all the resets,
What's that?
the ones that you reset to the first, you added those slots to the first.
Yeah, I made that day.
Oh, what was it before?
It was so.
Oh, okay, gotcha, makes sense. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Yes, just one note for the record, Your Honor. On Tuesday of this past week, my client dropped off items at my office that belonged to the complaining witness. It's some clothing items, jewelry and makeup, and a notebook that contains screen names and passwords and phone numbers for people it appears she had contact with on Discord and Snapchat. I've reached out to the prosecutor's office twice this week to try to arrange for an opportunity to have this turned over. I don't know if the contact information that I have is incorrect, but I have not heard back from the prosecutor about this information.
I sent him a follow-up email today. I apologize. I've been busy all week, and I just haven't had time to respond to anything.
Understood. It's just
Trial this week.
I just want to make sure that it goes on the record that I've had this for a few days now. I just want to make sure that everybody knows I'm not trying to keep it from the prosecutor. I'm sure it's going to be important.
Okay, sounds good. I guess you all can make arrangements about that off the record. Any additional matters?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing further from the defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Leonard.
Thank you, Your Honor.
You're welcome. Mr. Williams?
Yes.
Okay, so on 2 devices, merge your video. Why is it trying to merge me with Addie? That's not what we want to do. Zoom had some issues. Okay. And Mr. Hester here with Mr. Wells Tanner.
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Craig Wells Tanner, file number 21-01608, council appearance.
Good morning, Your Honor. Assistant Prosecutor Attorney Adam Pfeiffer on behalf of the people.
Thank you, Your Honor. Edward Hess on behalf of Mr. Wells Tanner. Mr. Wells Tanner is appearing in person, standing to my right at the council table.
Okay, Mr. Wells Tanner, today was the date and time set for a probable cause conference. You have an examination scheduled for next week at 9:30. Council, will we continuing to exam?
Yes, Your Honor.
Yes, Your Honor.
Any matters we need to address while we're on the record today?
Yes, Your Honor. People do have a matter that needs to be addressed. I made contact with the victim yesterday. I was actually anticipating her appearance this morning, but I believe there was trouble with her getting off work. She informed me that the defendant has been calling her since he was released from jail and telling her not to come to court. This is backed up by when I ran her number in the lockup system and showed that when on the day that he was arrested, there were 9 calls made to her number from lockup. The name that is given when the opportunity is presented is the name Pint. She informed me that that is his nickname, and that is further backed up by the police report where in the description of the defendant, he has a tattoo with the word pint on one of his biceps. That's apparently his street name. Now, as a result of this, I would ask that there be a P3 hearing set for the examination date, but further, I would ask that he be remanded because of this information.
So your allegations is that since the jail release, which
I believe he was released on the 5th, Your Honor, because that's when the calls from lockup stopped.
okay, and so there were your allegations, there were calls from lockup and then some additional calls.
Yes, Your Honor. She told me that he called her at 1:15 a.m. technically yesterday.
Counsel.
Yes, thank you, Your Honor. I was made aware of these allegations this morning by Mr. Pfeiffer. Excuse me. I would respectfully demand a trial as to these alleged contempt of court matters to be set at the same time at the preliminary examination. He denies having violated any of the court's orders. As far as the prosecution's bond motion goes, Your Honor, I haven't reviewed the records in any detail, but my understanding from my client is that these attempted calls from the city lockup would have been placed prior to him being given a no contact order at arraignment. Yes. I don't know about that. I haven't looked at the times, but that's what my client says, and that's a plausible defense. And all of these things need to be explored in greater detail by the court. I don't see any reason why Mr. Wells Tanner's bond should simply be revoked. He has been released from jail close to his bond. I respectfully ask that bonds continue and this matter be adjudicated by the court next week.
To be clear, Your Honor, yes, the time frame of the calls from lockup do appear to be before the arraignment time, which is usually around 1:15 in the afternoon. The fact those calls were placed is what lends credence to the victim's claims that he's been calling her since he was released.
Gotcha. So the calls from the jail would not be the basis of a PA53 violation.
Correct, Your Honor.
Gotcha. Okay, I don't have it. Do you have a report that's going to be coming as it relates to the violation?
Yes, I'm having her meet with police detectives in order to take a report about these contacts.
Okay, so Mr. Wells Tanner, for your information, the request is for a PA53 violation. That means a violation of your bond conditions. You were arraigned on the 5th by Judge Cynthia Ward. She advised you that there was a no contact order in place as it relates to a Sierra Johnson and an Esther Johnson. You were not to have contact directly or indirectly with either, and you were not to be within 2,000 feet of wherever they were. You were also placed on a GPS tether. You're on a tether, correct? Yes, ma'am. Okay. And so the allegation is that you violated the no contact order by making contact. I don't have a report, but I want to advise you that you have the right to have a hearing on that. And you have the right to have the prosecution put forth evidence to establish beyond a reasonable doubt whether or not you violated the terms of your bond conditions. If the court determines that your bond conditions were violated, your bond could be revoked. You could be sitting in jail while this matter pens. Do you understand that? Or you could be found in contempt of court. So that means you violated a court order. You could be found in contempt. That's punishable with the maximum penalty of 93 days in jail and or up to $7,500 in fines. I am positive there's no phone call worth $7,500 in fine. Okay. I'm also positive that if there's phone calls that are being made in violation of a bond condition, Mr. Pfeiffer's gonna make it his business to find out about it, okay? So we're gonna set this for a hearing. We're gonna enter a plea of not guilty on your behalf. And this matter is going to continue to hearing on the 21st, correct?
Yes, Your
I have 21st. 2-1. Did you get another date?
I got, well, when I got my paperwork, I had the 14th and the 24th for both.
So the thing is, whenever we give you a notice to appear, we give ourselves one, we print them twice.
Yes.
Mine says the 21st. You sure yours says the 24th?
Oh, I could.
Okay, we'll print you out an extra one today because this definitely says Friday, the 21st.
Yes, ma'am.
The
Okay,
defendant has multiple criminal files in this county, so that might be a reason for the confusion.
well, the 24th of April is a Monday and we don't do these on Mondays, okay?
Yes, ma'am.
So if you have a case, a misdemeanor, maybe you might be seeing us on Monday, but if you have something else, you gotta check your calendar. You have a cell phone,
I don't have one.
I would just make sure you put your dates in there so that
Yes,
you can
yes,
keep up
yes,
with your
ma'am, yes,
dates.
ma'am.
Okay, do you have any questions at this time?
No, ma'am.
I'm gonna deny the motion to revoke bond because he's on GPS tether. I don't have any allegations of violating the restricted zone.
Understood, Your Honor.
But I am gonna reiterate, there is a no contact order. You have to have contact directly or indirectly with Sierra Johnson and Esther Johnson. Do you understand that?
Yes, ma'am.
You understand what
Yes.
no third party contact would mean?
Yes, that means like don't have nobody, maybe from my family or someone outside of me try to contact her.
Correct. Any additional matters for the record?
Not from the people, Your Honor.
I wanted to tell you, Judge,
You're, excuse me. Were you gonna come, Judge? Just for-
they established that already. Okay. Nonetheless.
Nothing further, Your Honor. Thank you.
Okay, we'll see you next week.
Thank you. Have a blessed day.
Thank you.
You get court on Tuesday.
I'm sorry? It looks like you do have another file on the 24th, sir, so. you
Oh, it
do-
is something. on
But it
the
ain't this one, okay? You do have another one, so don't skip the 24th.
I believe it's a misdemeanor domestic case for the same.
This, am I on that case? Gotcha. This one. Mr. Williams,
Yes, ma'am.
do you have a shirt that you can put on?
Yeah, 1 second, I'm sorry.
Okay, who's ready to roll? Lex is gonna be a plea. Have we seen Carlos Clark? Plea for Alan? Which one? Secret Richards on Williams, right? Let me get up. You're on one, okay. We're on the record in the matter of the people of the state of Michigan versus Gabriel Michael Williams, file number 23-01028, council appearance.
Brian Ring on behalf of the people. Luke Goodrich from the Public Defender's Office here to represent Mr. Williams.
Okay, Mr. Williams, today was the date and time set for the preliminary examination. You were scheduled to be here at 8:30 and you failed to appear. I did issue a bench warrant, but I'll quash it at this time. Let's see. Are we continuing to exam next week?
Yes, Your Honor.
Okay, so Mr. Williams, your exam is scheduled for the 21st of April at 9 o'clock in the morning in person at the court. Okay,
Oh, okay.
do you have any questions?
No, not right now.
Okay, sounds good. We'll see you in court next week at 9 o'clock in the morning, okay?
Yes, ma'am.
Can you confirm your phone number for me?
I don't have one right now. My phone is in the police station right now. I don't have a phone number. I'm sorry.
Okay, whose phone are you on now?
My neighbor's down the street.
Okay, sounds good. Well, we'll see you in person next week, okay? Be in contact with your attorney throughout the week when you get an opportunity, okay?
Okay.
You're free to go. Thank you.
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Tyrese Letts, file number 23-00041, council appearance.
Good morning, Your Honor. Angela Delvero on behalf of people.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Letts, who's standing to my right today.
Okay, good morning. Today's the date and the time that was set for a preliminary examination, but my understanding is there's a plea.
That's correct, Your Honor. We'll be adding count 2 of aggravated domestic violence upon the defendant's guilty plea of added count 2. The people will be dismissing count 1 on the habitual third offender enhancement. Oh, further, the plea agreement also indicates the defendant will be seeking the protection under 769.4A. People have no objection to that.
Mr. Goodrich,
That is an accurate statement of what the plea is.
are you pleading today?
Yes.
Oh,
Oh, I'm sorry. It's in my hand.
oh. Thank you. Okay, I have an advice of rights and plea information sheet with today's date on it. This is your signature, sir.
Yes, ma'am.
Did you read this document?
Yes, ma'am.
Do you understand the rights listed here? Do you have any questions about these rights? You're willing to give up all of these rights in order to accept the offer? Say that with some more surety. I couldn't hear you.
Oh, yes, ma'am.
Okay. Oh, so you understand that you're gonna give up your right to the presumption of innocence in this matter in order to plead guilty?
Yes, ma'am.
You understand that you have the right to have the prosecution prove your guilt beyond a reasonable doubt at trial? You want to give that right up? Okay, you have the right to confront and cross-examine any other witnesses the prosecution intends to call. You have the right to call your own witnesses or present evidence at trial that you believe would further defense to the charge. You understand that? Are you willing to give that up as well?
Yes.
You have the right to remain silent at trial. You want to waive that right also?
Yes.
Anybody threatening you to get you to waive your rights?
No,
Has there been any promises made to you in exchange for you waiving your rights?
No.
Are you currently on probation or parole?
no, ma'am.
Are you on bond on any other matters? Okay, you understand that a guilty plea can result in the conviction that you may need to report to your employer.
Yes.
A guilty plea can result in a conviction that may have impact on travel or immigration status that you may be seeking. Do you understand that? And you still want to waive your rights? Okay. Are you entering a plea because you believe you're guilty?
Yes, ma'am.
As to the added count 2 of aggravated domestic violence, how do you plead?
Guilty.
Have a factual basis, counsel.
Thank you, Your Honor. Your Honor, we would like to do the factual basis for the original charge in this matter of child abuse, 3rd degree. Mr. Letts, on or about May 5th of 2022, were you at a location 3616 Deerfield Street?
Yes.
Is that located in the city of Lansing, County of Bingham, State of Michigan?
Yes.
And while you were at that location, did you get upset at your son, Tyrese Jr.?
Yes.
And as a form of punishment, did you get out a belt at that point?
Yes.
And did you use that belt to strike Tyrese Jr. multiple times?
Yes.
And did that cause physical harm to Tyrese Jr.?
Yes.
Your Honor, I believe we have a factual basis to the underlying charge of child abuse in the third.
I would agree. Your Honor.
Thank you. The court is satisfied with the factual basis. I will accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing on June 15th at 8:30 in the morning. You need to go down to our probation department when you leave here so they can get you set up for your pre-sentence interview, okay? Do you have any questions at this time?
We did complete a plea form, Your Honor, and it has the PAC code for the added charge on it.
Thank you so much. Oh, very good. Any additional matters for the record? counsel?
No, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set, sir. We'll see you at your sentencing. Mr. Sards. Okay, we're on the record in the matter of the people of the state of Michigan versus Darnell Thomas, file number 22-00558FY. Counsel appearance.
Brian Ring on behalf of the people. Morning, Your Honor. Jacob Sarts, the fourth assistant public defender here on behalf of Mr. Thomas. He's at council table. He's standing by.
How are you, Mr. Thomas? Very good. Today's the date and the time that was set for preliminary examination. How are we proceeding?
You know, this time the people would be asking for an adjournment of this matter. There was some confusion on, at least by the people when we left this matter last time. I was under the impression that Mr. Sart's withdrawal was granted and that Mr. Thomas was seeking independent counsel. I've not had any further contact with any attorneys since then until just today when I learned that Mr. Sart's was indeed still on it.
I do have a very vivid recollection of a motion to withdraw. And there was some level of breakdown between the two. How are we doing now?
Your Honor, I've been prepared for today's preliminary examination. Mr. Thomas and I cleared the air. We are communicating now again. I was in a position to proceed today. I was still listed as the attorney of record for this case. From what I recall, ultimately, Mr. Thomas withdrew his request to represent himself, and ultimately he informed the court that he would prefer to keep me on as counsel. Now, I'd be happy to review the transcripts. My memory was wrong in that, but in my
My
role-
notes stated that the motion was withdrawn.
Thank you, Your Honor. So, we are prepared. We are ready to proceed today. At this point, I would oppose any objection to, I would oppose any request for an adjournment. I certainly appreciate Mr. Ring's, concerns on this issue, but respectfully, we were prepared and ready to proceed today. In terms of the communication issue, well, Mr. Thomas has always been very insistent. They wanted to have his preliminary examination, and we were prepared to proceed with it last time. So that would be my position on it, Your Honor. I certainly understand that, under the circumstances, perhaps that Mr. Ring and I have not talked about this case recently, but that was because I was under the impression that we were going to proceed with a prelim. But it was going to be with myself or possibly if Mr. Thomas had retained somebody in between, but I was expecting we would run an exam. Thank you.
Okay, well, I understand that you're making a motion to have this matter dismissed without prejudice, but I can assure that doesn't sound like it'll be in the interest of judicial economy. This is probably just going to reissue the case today. And your clients have to come back and be rearranged.
Well, that's understood, Your Honor, but ultimately, Mr. Thomas is, I'll defer to him at this particular moment in terms of whether he would prefer to have a discussal at this time. And we've discussed this issue, and the burden is on the prosecutor. And at this point, this case goes back to allegations from December 31st of 2021. The complaining witness has now had a couple of occasions to show up. From what I understand, she's not appeared at either court date, and that will have to be a strategic choice that Mr. Ring and his fellow prosecutors will have to make in terms of whether they would ultimately be able to carry their burden past the preliminary examination or further down the road to trial. And those are,
My record stated that she was never subpoenaed to appear. Is that accurate?
at the first instance, we did subpoena the wrong address, or she did not receive that subpoena. I had been in contact with her at the first time when we adjourned this matter the last time, Your Honor, and I have not had contact with her since then.
My notes from March 16th stated that prosecutor had recently been in contact, which would given indication to the prosecution that they have a witness that's willing to appear, but was not able to do so at that time. So with that being said, I'm going to deny the motion because it's not in the interest of judicial autonomy. And I'm going to reset it one last time for witnesses to be properly subpoenaed.
Thank you, Your Honor.
You're welcome.
June 1st at 9:30.
June 1st at 9:30. You have any questions today, sir? Oh, yeah, you can talk if you have any questions.
Oh, I didn't know how to say it.
What do you mean? Who told you you couldn't say anything?
Every time I say something, I get in trouble.
When did you get in trouble?
So I was just on record.
When did you get in trouble with me?
No, but this is on record, right?
We're on the record.
So I've never, like, whoever the witness is, I just want to get this understood, that y'all never had no contact with
You're
it.
asking a question? Is that your question?
Yeah,
Your question is if
that's why this is.
who's
getting
ever had
adjourned.
any? No.
I mean,
they-
not adjourned, but yeah, that's why this.
Let
is
me
getting
clarify.
adjourned.
And my understanding,
I'm
this-
confused.
I get the same information you get when we're here, okay? My understanding is on March 16th, the victim had not received a subpoena and that the prosecutor had spoken to the victim prior to that. That's how he knew the subpoena went to the wrong place. So there was a request to adjourn based on that. However, then we had the issue between you and Mr. Sarts as well, where you made a motion to have new counsel, and then you two had a little back and forth, and then you withdrew the motion somehow along the way that caused some confusion for the prosecutor, and he was under the impression that you were seeking new counsel. And so there still has not been a proper subpoena of the witness. There's a motion that your attorney has made to have the case dismissed today, but the dismissal would be without prejudice, meaning they have the right to reissue the charge against you. Mr. Ring, do you intend to reissue the charge if its case is dismissed?
I would intend to issue that
Yeah,
charge.
I understand.
Yeah.
But I just seen him and the other prosecutor winking, so when the guy was sitting with Mr.
They
Williams,
probably did, but
Yeah, but anyway, that's neither here nor there. What I'm saying is, he said right now that they ain't issued no subpoena or they got in touch with this witness.
no, he didn't say they've never been in touch. He said he spoke to before the last hearing. So he has been in contact.
So we adjourned, right? Is that what we're saying?
Correct.
Thank you.
You're welcome. Do you have any more questions? It's gonna be on the 1st of June at 9:30. We'll get you a
What's
copy of the
this?
notice.
This
This is
April
April
at 9:30?
at 9:30. Did you have a concern?
Oh,
Mr. Thomas, Mr. Doctor.
thank you.
Did you have a concern with that date?
Hey, can I get a copy now?
Yes, we'll get your copy.
No, a copy.
A cop?
Yeah, because it looked like I might I just plead guilty like for potential, I do life, without parole.
Okay, sure, let's talk about that. I got you. You know,
Thomas, I think your attorney wants you to go in the hallway.
Whoa, 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 whoa.
Like that.
Mr. Thomas, keep it together. Okay, is that the last felony we have today?
You definitely just threw this away.